Hi, I'm John Degasperis. I'm a personal injury lawyer in the Hudson Valley. In this video, I discuss how to prepare for your deposition and what to expect during your deposition held in a personal injury case. Remember, if you need a personal injury lawyer, give me a call. A deposition is essentially a question and answer session. Sometimes it's referred to as an examination before trial. It occurs during the litigation. The lawyers for the defendants will ask questions of the plaintiff. Then the plaintiff's lawyer gets to ask questions of the defendants and other witnesses. The proceeding is recorded by a court reporter. There's a transcript that's produced. The transcript contains every word that is said during the deposition. That transcript can be used as evidence in later proceedings in the case. And the deposition is one of the most important proceedings that occurs during a personal injury case. Three simple rules for a plaintiff in a deposition. If my client follows these three rules, they'll be fine. Don't lie, don't guess, don't talk a lot. Those are my three rules. Bring nothing to your deposition. The witness is obligated to testify based on memory only. So if the witness does not know the answer to the question or does not recall the information, they're allowed to say, I don't know, or I don't recall. They have to admit if there are notes or calendars or diaries if that question gets asked. But otherwise, witnesses should not be referring to their phones, to notes, to diaries, to calendar entries. You testify based on your own knowledge, that's it. Depositions typically take between 1.5 to 2 hours. On your more serious cases involving real catastrophic injury profiles or really complicated fact patterns, they can take much longer. Here in New York, the rules allow for up to 7 hours in a deposition. I think federal court cases are similar, 7 to 8 hours. However, if the parties need more time, the courts will often allow for more time, but they usually don't go beyond 3 or 4 hours. Most depositions these days are conducted remotely or virtually, and obviously that reduces travel time and makes things generally easier. I always ask my clients to come to my office for their deposition, no matter how far away they are. Of course, there are extenuating circumstances where I'll allow them to testify from some other location, but I want them here for several reasons. One, I have good internet, great technology, so we get that deposition started on time without any technological issues. I also want my clients close to me. Now, I will typically be at my own computer because it is a remote deposition and it works better when everyone is remote. But I want my client to know that I'm in the building, that I'm close by, that I'm here to answer their questions. Sometimes these depositions get emotional and I want to be there to support my client. So I always ask them to come right to my office. So the client should be comfortable. They should wear clothes that are representative of their true character in their everyday life, but it is an important legal proceeding. Sometimes they are video recorded. So I encourage clients to dress appropriately, whatever that may be, within their financial ability and their everyday clothing attire. So, but a nice shirt and pants, and what I always say is that the deposition is a personality contest. So it's not just the substance of your answers, it's your conduct and demeanor during the deposition that counts almost more than what comes out of your mouth. Short answers are important for a number of reasons. So first of all, you have to remember that there's a written transcript that's produced. And what we want from a deposition is clarity. So the best transcripts read with a short question followed by a short answer. And that's what we want to see throughout the deposition transcript, because it's so clear, it's easy to read. And remember, this could be later on. So a judge might read it, a judge might read it, and a adjuster might read it. And so it's important to have short answers. I always say the words no or yes are the most powerful sentences in the English language, right? They're words, but when you give a yes answer to a question, if that yes is followed by a period, it's a sentence, and it's incredibly powerful. When witnesses run on and give these narrative responses, there's a lot of ambiguity in there. There's a lot of wiggle room, and it really just invites more questions from the questioning attorneys, and that's dangerous. I want my clients in the room with other lawyers for as little time as possible. And so sometimes I'll equate a good deposition exchange to a really fast ping pong game where the ball's just bouncing back and forth. That's the best question and answer cadence in a deposition. The answer is no, but I understand why my clients and witnesses are nervous about depositions. They've never done it before. They're going to be questioned by the other lawyer. So what I always remind my clients is that you're the victim of an accident. You're an injury victim. You've done nothing wrong and no one thinks it, right? And so if you just remember that you've done nothing wrong, and you can actually help the defense and the defense attorney and even the insurance company properly evaluate your case, right? And I always tell my clients, remember, this is not a criminal investigation. This is not a federal indictment you're about to receive. This is a question and answer session based on an accident. The other side needs to know about you and your injury claim in order to properly evaluate the case. So if you do a good job during your deposition, you can actually do your case a lot of good. And then the final thing I always tell my clients is, I assure you, at the end of the deposition, you will breathe a sigh of relief and think to yourself, that wasn't that bad.